This week, Titanic director James Cameron, a deep-sea explorer himself, offered some harsh criticism of Ocean Gate for not following basic safety regulations. Here's some of that interview.
Finding a multi-seat vehicle where I intended to be the pilot, we'd go through all of the rigorous test protocols and review protocols that you have with, let's say, ABS, which is the American Bureau of Shipping, or DNV, or German Lloyd's, who are the major bureaus that class a sub. They call it classing, but it's basically certification. And I think it was unconscionable that this group did not go through that rigorous process. There's a great, almost surreal irony here, which is Titanic sank because the captain took it full steam into an ice field at night on a moonless night with very poor visibility. After he had been repeatedly warned by telegram, by Marconigram, by radio, during the day, that that's what was ahead of him. And so I think we're also seeing a parallel here with make sure if you're going to go into a vehicle, whether it's an aircraft or a surface craft or a submersible, that it's been through certifying agencies, that it's been signed off.
Seems like a basic point, doesn't it? While the U.S. Coast Guard is leading efforts to determine how the Titan sub imploded, Canada has its own investigation underway to determine the possibility, at least, of criminal liability for those 5 people killed on board. An effort complicated by the fact that OceanGate's founder and CEO, Stockton Rush, who once made comments about breaking safety rules in pursuit of innovation, was one of the victims. He died on the sub. Joining me now is Klaus. He's a maritime attorney and a U.S. Coast Guard licensed deep-sea captain. Good to have you on. Thanks so much for joining us.
Thanks for having me.
So he did not have any certification for this. He spoke about it publicly. He said, sometimes certification slows things down. Yeah. Sure it does. Does that contribute to the possibility of criminal negligence here?
I think it'll weigh into whatever litigation comes about from this. There was a statement at one point where he said something along the lines of safety at some point becomes a pure loss. And so you really have to wonder about the leader of a corporation who's going on an experimental trip like this in an untested vessel, making statements like that and sort of circumventing regulations that are there to really help the vessel and the safety of the crew.
Now, according to someone else who rode on the Titan, the waiver that customers signed, includes a long list of all the many ways a customer could die in the submarine. I think folks watching at home, we've all signed waivers before for, even simple things, right? Does that relieve the company of liability?
At some point, they're going to make that argument, but I don't really think that it's going to hold any weight. There's this legal axiom, caveat emptor, translates to buyer beware. Yeah. So you have to really consider the fact that the people going on this submersible had plenty of time to consider the risks, weigh them, look at the organization. So there is some onus on them in terms of making that decision. But then ultimately there is going to be litigation with regard to the company and what's left of the corporation now at this point. What do they have? Some other submersibles there and maybe some assets that can be taken. But it's a really interesting case in a number of ways because the submersible wasn't classed, as we saw in the video leading up to this, and it didn't have a flag of registry. So it wasn't registered to any country. Although the corporation is in the United States, the vessel that the submersible traveled on is out of Canada. And then you had citizens on board the submersible from the UK, from Pakistan, right, from France, and from the US. So this is really an international issue.
Does it matter that this took place in international waters, the actual event?
It matters in terms of it's going to be really difficult to figure out where to litigate this matter. There's the United Nations Convention on the Law of the Sea, which really dictates how things are handled on the high seas when it comes to vessels and even submersibles. And so with all of these international considerations, this may be something that rises to the level of litigation at the UN level.
Let me ask you this. You're a maritime attorney. You told me you've dealt with cases on the surface before, shipping, et cetera. Have you ever dealt with a case like this where there was a safety event where the person involved didn't go through any sort of classing, certification measures, and even spoke publicly, as Stockton Rush did, about the sort of inconvenience of safety protocols like that?
I've never heard of anything like this. This is completely unique, and at some point, you have to wonder about the thought process leading up to this. Typically, when we litigate matters regarding commercial vessels, they're classed, they're under a flag of registry, they have safety management systems, everything is by the book and managed well, and that's for ships that travel on the surface. You would think the same would apply to ships under the surface.
Right, where the danger arguably greater, particularly when you're 2.5 miles down. Klaus, Luda, thanks so much.